ang personal na gagawa mismo ng mali. Kaya rin sa ating justice system, particular sa Revised Penal Code of the Philippines, may tinatawag na principle by direct inducement. Kung susuriing mabuti, ang mga aligasyon na ito ay tumutumbok sa isang conclusion, that the President most likely is not anymore fit to govern. Malayo pa ang proseso, pero malayo na ang narating ng hangarin na magkaroon ng mas maayos na pundasyon ng ating pamahalaan. Madam Chair, in view of the foregoing, I respectfully submit that the impeachment complaint be deemed sufficient in substance and that it accordingly be allowed to proceed to the next stage of the proceedings. Magandang araw po muli sa ating lahat.
Completes and concludes his manifestation of position in as far as sufficiency in substance of the Jesus complaint is concerned. We understand that at the end of our deliberation on the sufficiency on substance with respect to this impeachment complaint of Attorney De Jesus, of our proceeding, considering that there are 5 offenses alleged from the members of the committee in accordance to the grounds alleged in the impeachment complaint. Let the chair reiterate that while we discuss it on the basis of grounds at the end of our deliberation, we will be voting on the sufficiency in substance on the entirety of the impeachment complaint. At this point, we will be eliciting the comments, positions, or even questions of the members of the Justice Committee with respect to the sufficiency in substance of the Jesus complaint, which position was manifested already by our endorser, the Honorable Nisay. We will begin with the first offense. Let me read. Respondent ordered and enabled the kidnapping and surrender of former President Rodrigo Roa Duterte is anchored either any or all of the following grounds: culpable violation of the Constitution or betrayal of public trust. Members who wish to manifest.
Madam Chair,
The Honorable Ridon is recognized.
I think prior to even talking about anything else, I think we need to state for the record that what is important in the submissions would be 2 things, no? Personal knowledge or authentic records that had been submitted as part of the impeachment complaint. For the first impeachment complaint, may we know from the Secretariat on what the annexes, on which annexes had been submitted as authentic records, Madam Chair?
May we ask the endorser if he is willing to answer the question instead of the Secretariat answering the question? The Honorable Ridon is asking on the annexes attached to the complaint in support of the offense of kidnapping and surrender of the former president to the ICC.
To be clear, Madam Chair, this is not just a question on the specific ground, but as a general question on all of the submissions, because you have annexes here, but we would want to know whether what had been submitted are authentic records, particularly whether the submissions are certified through copies of particular official documents. Madam Chair.
The chair stands corrected. The question pertains to the entirety of the impeachment complaint.
And to explain why we are asking this, in previous impeachment complaints, the complaints had been rejected by the House Committee on the basis of that these impeachment complaints had not been submitted because on the basis of personal knowledge or because of submission of authentic records. So I think the same standard
Point of order,
should apply
Madam Chair.
to
Point of order.
The Honorable Ilaga is recognized with the indulgence of the Honorable Ridon.
Representative Ko.
Honorable Ko.
Okay, thank you, Madam Chair. Madam Chair, to my understanding, for now, we are in the stage of assessing the sufficiency of substance of the impeachment complaints. We are observing Rule 3, Section 5 of the 20th Congress Rules of Procedure in Impeachment Proceedings, which provide the requirement of substance is met if there is a recital of facts constituting the offense charged and determinative of the jurisdiction of the committee. So for the purposes of this exercise, Madam Chair, what we need to do is to determine whether in the complaint there is a recital of facts which, one, provides the jurisdiction of this committee, and number two, whether it constitutes the offense charged. So we do not yet need to enter into a discussion whether the recital of facts actually is based on personal knowledge or based on authentic records. That can come later, Madam Chair, in the hearing proper, when the committee has already determined whether there is sufficiency in substance, whether the facts alleged in the complaint constitute the offenses that are being charged, which in the case of Honorable Nisa, would be corruption, betrayal of public trust, etc.
Any member who wishes to
Madam Chair.
respond? The Honorable Tino is recognized.
Thank you, Madam Chair. In addition to the point made by Representative Ko, I would like to point out that the matters raised by the Honorable Ridon have already been settled in yesterday's proceedings, namely the determination of sufficiency in form, where precisely the committee found that it was indeed sufficient in form, meaning that the complaints, both complaints were verified complaints based on personal knowledge and or authentic records. So that point has already been settled as far as the rules provide. No? And any further discussion on those is out of order at this stage.
The Honorable Chua is raising his hand.
Sa kidnapping. Tama po ba?
With due respect, the Honorable Chua, there is a pending query on the validity of the question of the Honorable Ridon with respect to the attachments to the impeachment complaint of De Jesus. This is being disputed by the Honorable Ko and the Honorable Tino, as they are claiming that this should be asked after the determination of sufficiency in substance, if I stated it correctly. So let us dispose first this matter before we proceed to other issue. The Honorable Vice Chair Dumogan.
Thank you, Madam Chair. This is an impeachment complaint, and we are at the stage of determining sufficiency in substance, which should contain narration of facts. The definition of, if there are narration of facts which are not bare allegations, narration of facts which are not bare allegations, which can possibly lead to a proof that there is constitutional violation, which is an impeachable offense. Madam Chair, Your Honor. So I do not agree that just allegations will be considered to determine sufficiency in substance. I
Madam
respectfully submit.
Madam Chair.
The Honorable SDML is raising his hand. SDML Lawrence Defensor is recognized.
Thank you, Madam Chair. If we look at the heading simply to accept a recital in an impeachment complaint. We have the duty to this committee. So it is only proper that the recital of facts should at this stage be at least supported by evidence for us to declare that the complaint is sufficient not only in form but also in substance. Thank you, Madam Chairman.
Thank you.
Madam Chair.
The Honorable De Lima, and then Honorable Co, and then Honorable Tino, and then Honorable Garbin. Okay, one after the other. And then Honorable Rodriguez. The Honorable De Lima is recognized.
Thank you, Madam Chair. Good morning, everyone. Technically and strictly, and if we go by the standard set the House rules itself, the rules of procedure in impeachment proceedings, it's supposed to be just, we just have to look at whether the complaint has a recital of facts constituting the impeachable offense. The jurisdiction, this committee has jurisdiction. Now, the recital of facts constitutive of impeachable offense charge, in addition to what has been articulated earlier by the Honorable Chairperson about, it must not be based on conclusions. I would wish to further elaborate on exactly what sufficiency in substance mean. When we talk about substance, it refers to whether the complaint alleges ultimate facts that, if hypothetically admitted, would constitute an impeachable offense. So hypothetical admission lang. Hindi pa natin titingnan kung totoo o hindi, o may supporting evidence ang isang allegation of fact. And as I said, in addition to the standards set in our own rules of impeachment, rules in impeachment proceedings, a complaint is sufficient in substance when it, number one, narrates specific acts or omissions, not mere conclusions. Number two, it shows a nexus, a connection between the acts complained of and an impeachable ground. Kailangan konektado yung mga allegations of facts doon sa constitutional ground. Number three, should be intelligible and coherent, allowing the respondent to meaningfully answer. Number four, it's not purely speculative or opinion-based. And then, pwede rin, in terms of just checking the sufficiency of the entire complaint, whether we can also look into whether it's supported by annexes or references, although proof need not yet be conclusive. Dahil nga po, evidence is not weighed at this stage. The test is allegational sufficiency, not credibility or truth. Yun po ang aking position. Thank you very much.
Thank you, Honorable De Lima. Now we recognize the Honorable Co.
Thank you, Madam Chair. Good morning to the committee. Once again, I also submit and I agree with the manifestation made by Representative De Lima. And I would just like to add further in regard to the discussion on ultimate facts. Given that actually the rules of court superiorly applies to the rules on impeachment under Section 19, I'd like to read Rule 8 of the Rules of Court of the Philippines, wherein it says that pleadings are required to set forth relies for a claim or defense. And as stated earlier, the ultimate facts are generally what is the allegation of the offense, the acts or omissions, and how it relates to the offense charge. That's different from evidentiary facts, which is not required to be included in a pleading yet, and that can come later on when we enter the hearing proper. And it's different also from conclusions of law. No. So right now, what is the complaints are sufficient in substance as to whether ultimate facts alleging the offense charged is sufficient.
Our parliamentary status, we are determining whether or not the question of personal knowledge and authentic records, specifically with respect to the attachments, should be considered in the determination of sufficiency in substance. Moving forward, we now recognize the Honorable Tino.
Thank you, Madam Chair. The Honorable De Lima and Co, they have eloquently made the point that at this stage, this committee is not supposed to determine facts. This is not the proper stage for that. That will involve the hearing proper. No? So at this point, the complaints may be determined as sufficient in substance if they are found to allegations sa complaint. Yun lang po, Madam Chair. And as to the question of authentic records and so on, my position there is that dapat tinanong yun kahapon. Dahil yun yung precisely, yun yung inaalam, no? Whether or not the verification requirement was satisfied. At ang sinasabi dun sa verification that the complaint is based on personal knowledge and or authentic records. And that has already been settled by the committee. Thank you, Madam Chair.
Thank you, Honorable Tino. Now we recognize the Honorable Garbin.
Thank you, Madam Chair. We are all guided here by the rules of impeachment of this House, and the requirement of substance is met if there is a recital of facts constituting the offense charge and determinative of the jurisdiction of the committee. The complaint before us, filed against the President, alleging impeachable offenses, namely culpable violation of the Constitution. Major allegations by category is the surrender of former President Rodrigo Roa Duterte to the ICC. It is noteworthy to mention, Madam Chair, and to this honorable committee, that the case before the Supreme Court questioning the constitutionality of the said alleged surrender and kidnapping, case of GR number 278 of habeas corpus of Rodrigo Roa Duterte is still pending. In fact, the status of the case right now is that parties were required to file position papers. And so, therefore, Madam Chair, to my mind, these are mere conclusions, not established facts, Madam Chair. Vote and explanation to my vote, Madam Chair. Thank you.
While the opinion of the Honorable Garbin on the first offense is significant, we will be holding our discussion on the first offense until we thresh out the question on whether or not we will consider the attachment if they are authentic record for the purpose of determining sufficiency in substance. That is our parliamentary state right now. The Honorable Rodriguez.
Madam Chair, after hearing the discussions, I am fully satisfied.
So before we proceed to our discussion on the offense, that is kidnapping, we wish to thank the significant views and opinions as to the question of whether or not the attachments should be considered for the purpose of determining sufficiency in substance, no? And I understand that there are varying opinions. Some members would say or said that they should not be considered and we should stick on what are stated in the impeachment complaints, while some would say that they are necessary for the purpose of determining the substance or the sufficiency in substance. The chair wishes to elicit a motion as to whether or not we will include the attachment if they are authentic records for the purpose of determining sufficiency in substance as a preliminary matter.
Madam Chair.
The Honorable Ko.
Okay. Madam Chair, I move that for this portion of the discussion, the body contemplates whether the facts alleged in the complaints constitute the offense charged. And at this stage, we do not need yet to cross-check or check it whether it is supported by the evidence, be it based on personal knowledge or authentic records. I so move, Madam Chair.
Madam Chair,
The Honorable Rodriguez.
point of order.
The Honorable Rodriguez is
The
recognized.
Honorable Ko is a party of the case as the endorser also in this particular proceedings. And so therefore, we will request all the endorsers that in the deliberation of the committee, they cannot participate. This is a proceeding akin to a preliminary investigation. And so the complainant and their lawyers could not be the one moving to the prosecution to proceed with the case. And so therefore, with due respect, let us allow our members, and of course, we will appreciate you at the proper time in the discussions to elaborate further the complaints. But as already parties, the party is the De Jesus complaint, Attorney De Jesus, and Jet Nisay, the endorser. Masa, the three respected gentlemen and lady. And so, the other party is the President, President Ferdinand Bongbong Marcos. And we are the committee investigating. So therefore, let us wait for another member to move whatever is the motion about. So I would like to seek the ruling of the chair.
Would you like to comment to that, Honorable Ko, before we rule?
Okay. Thank you, Madam Chair, Honorable Rodriguez. While I understand the logic of the manifestation, we'd just like to manifest that the three complainants of the second impeachment complaint are members of the Committee on Justice. So again, we also respectfully seek the ruling of the chair in regards to this matter, whether or not we can participate in the deliberations of the discussion on the first impeachment complaint, because as at least provided by the rules, it is a right that is provided upon the members of the Committee on Justice. Thank you, Madam Chair.
The chair recognizes the right of each member of this committee, notwithstanding his dual capacity of being an endorser as well. So, in resolution of the question as to the capacity of the Honorable Court to raise a motion, the chair rules in favor of the authority and right of the member, notwithstanding the fact that she is an endorser as well, to raise the necessary motion.
But Madam Chair,
Before that, Madam Chair, we respect that ruling. Would therefore, in the voting of these two complaints, will Representative Ko be voting?
To the honorable members of this committee, we are exercising a very important process, and it is not the intention of this committee to impair whatever right and authority each of the member has in this committee. So if we are upholding the right of a member who is at the same time an endorser to raise a motion we are likewise upholding her right to vote on the motion. Honorable Ko?
Madam Chair, before I answer, perhaps in the order also of the matters, given that we'd like to thank the Madam Chair on the ruling, but in deference no, on the discussions, I'd like to retract my motion and would allow the body to make that motion, no, given that there's this question. But nonetheless, we, as a member and in deference to the ruling of the chair, we will continue to participate in the discussions.
The chair has ruled already.
Okay.
The motion by the Honorable Ko is
Sustained.
upheld by the chair.
Okay.
So I will just be requesting for the rephrasing of the motion because it should not entail the evidence attachment. The question only is whether or not the attachments as authentic records should be considered for the purpose of determination of sufficiency in substance. We are not yet on evidence. The Honorable De Lima is recognized.
Given the withdrawal by the Honorable Rene Co of her earlier motion, may I therefore make this motion? In duration of sufficiency in substance, the determination of the authenticity of authentic records, if any, as attached to the complaint.
There
Do not
is-
consider.
There is a motion to exclude the authenticity of the attachments for the purpose of the determination of sufficiency in substance. Do I hear a second? Is there any objection?
I object, Madam Chair.
The motion has been objected to. We shall now divide the House. Those who are in favor, guidance of everyone, the motion is to exclude the authentic record constituting of the attachment for the purpose of the determination of sufficiency in substance. Those who are in favor of the exclusion of the attachment, please raise your right hand. You may put the issue of authenticity of attachments for the purpose of determination of sufficiency in substance. In other words, whether we exclude or not. So if you vote in favor, we exclude the issue of authenticity of attachments. If you don't vote in favor, then we discuss on the issue of authenticity of attachments.
Chair,
The Honorable Tino.
may I clarify that the exclusion of the determination of authenticity is only for this stage, no? Because the position is
Of
that
course.
that should properly be done in the proceedings proper.
Correct.
Not at the stage of determination of sufficiency in substance.
Correct.
Para malinaw lang po, kasi baka isipin na yung motion ay ayaw na ma-determine kung authentic ba yung records o hindi. Ang sinasabi lang po, hindi po ito ang tamang panahon para
Correct.
gawin yun.
Okay.
May I be recognized, Madam Chair?
The Honorable SDML is recognized.
Just for purposes of determination of sufficiency of substance, I vote not to exclude. I vote to include.
That's
Kasi baka merong mga impeachment complaint na wala naman palang attachment o hawsyaw ang mga attachment. I am not saying na we will discuss the contents of the attachment. That would be for the proper hearing after we determine the substance. Ang sinasabi ko lang, dapat kapag may recital of facts, ang naka-attach dito ay mga dokumento na may probative value naman for proper hearing. Para hindi hawsyaw o haka-haka lang ang recital of facts.
Madam
I
Chair,
submit, Madam Chair.
Madam Chair.
The Honorable Keith Flores.
Madam Chair, at this point, Madam Chair, I think it's enough that we rely on the verification under oath by the complainants themselves that it is based on true and correct facts and that it is also based on authentic records. Under oath, Madam Chair.
Madam Chair.
The Honorable Ridon.
to be very clear po, I'm only pertaining to the first impeachment complaint, and it's actually it's just a factual question. Which of the attachments are in fact certified through copies, no? Gusto lang ho namin malaman. We are not conflating this question on whether or not this proceeding should in fact even proceed. Kasi sa totoo lang, kahapon po, I was raising it already in the determination of form na in fact, in previous impeachment proceeding, the committee, on the basis of the absence of personal knowledge and authentic records on the question of sufficiency in form. So, ibig ko sabihin, if we will not be allowed to determine this at this point, kailan po natin yun madedetermine, hindi ba? So, yun lang ho actually, and it's not even my question. My question is basically just factual. Doon po sa first impeachment complaint, alin po doon sa attachment, yung sa totoo lang, certified through copy, at alin po doon sa mayon, yung hindi, without conflating it onto whether or not this complaint should proceed.
Madam Chair,
Honorable Rodriguez.
we are not yet there.
Rodriguez.
We are not yet there. We are still would pertain to what is stated in the complaint. That is why it's annexed. We cannot go to the annex now because we are only according to the rules, and the complainant should be able to yet go to the annexes. They are already mentioned in the complaint because otherwise the annex standing alone cannot stand. It to enforce a statement of fact.
To all the members, we've heard a lot of varying opinions. Some are in favor of excluding the attachments for the purpose of determination of sufficiency in substance. Some are not in favor. But for the guidance of everyone, before we proceed to voting, we are requesting the Honorable De Lima.
Thank you, Madam Chair. I move to exclude the determination of the authenticity of biddings.
In favor of the motion. The motion is to exclude. Raise your right hand. Motion, please raise your right hand. You may put down your hands. Those who abstain, please raise your right hand.
Madam Chair, can I just say my
Please wait, Vice Chair Dumogan, until we resolve the motion. Can we have the number of votes? Let me reconfirm. I find the numbers a bit doubtful. Okay. The motion, again, is to exclude determining sufficiency in substance. Those who are in favor of You may put down your hands. Those who are not in favor of the motion, please raise your right hand. With 21 in favor of the motion and 24 against the motion, the chair declares not to exclude the authenticity of the attachment in the determination of sufficiency in substance. So ruled.
Madam Chair? Madam
Thank you,
Chair?
Madam Chair.
Madam Chair?
Can I call first Vice Chair Dumogan?
Thank
Vice
you.
Chair Dumogan and then Honorable Tino. You're
Very
recognized.
short. Thank you, Madam Chair. I'm happy that we voted against the motion because if we voted in favor of that motion, it will be violative of Section 3. The Section 3 requires, based on authentic records, in all of a sudden, in the determination of sufficiency in substance, you will waive the determination of authenticity of document. It's violative of Section 3.
Thank you,
Madam
Vice Chair Dumogan. The Honorable Tino?
Madam Chair.
The Honorable Tino.
Thank you, Madam Chair. Madam Chair, in view of the fact that the chair herself had to call for a vote 3 times, and in the second instance, she even commented on the record na hindi siya makapaliwala sa resulta. Okay? So in other words, medyo wala pong clarity dun sa naging botohan. I move for nominal voting on the point, Madam Chair.
The Honorable Flores is recognized.
Madam Chair, Congressman Tino, I saw the numbers admitted by the Secretariat. We lost on both counts, sir.
Let us be reminded that this is just a preliminary matter, no? I hope we will be recognizing the decision of the majority of the committee in as far as this issue is concerned.
Madam Chair.
The Honorable Ko.
Thank you, Madam Chair. Madam Chair, with due respect to the members of the committee, it is this representation's belief that hindi po actually dapat subject to ng vote because the rule provided in the rules on impeachment proceedings that in this stage, to determine the sufficiency in substance, ang kailangan pong gawin is to determine whether there's a recital of facts constituting the offense charged. That's it.
With all due
hindi po
respect,
ito
the
nakalagay
Honorable Ko,
otherwise.
the committee has ruled already. The Honorable Garbin.
Thank you, Madam Chair. I've been hearing the position of the movant, and they invoke the rules of court as in suppletory character. Now, while impeachment is a political process, the determination in sufficiency in substance is analogous to a judicial requirement that a pleading must allege ultimate facts constituting a cause of action, not mere conclusions of law or argumentative narratives. Under Rule 8, Section 1 of the Rules of Court, pleading must state the material facts relied upon and not evidence on general averments of wrongdoing. Applying this standard, Madam Chair, by analogy, the first complaint largely asserts labels and conclusions, such as the betrayal of public trust. And therefore, it is but right that the majority of the members should assert to include and determine the authenticity of the attachment in the said complaint. Thank you, Madam Chair.
The Honorable De Lima.
Just a short comment, Madam Chair.
You're recognized.
Given the vote to still include the determination of the authenticity of supporting documents or authentic records, I believe it will unnecessarily delay the proceedings and prejudice the causes of any complainant. And it went outside the very essence of what is the determination or what is sufficiency in substance as explicitly laid down in our own rules. Tatagal po ang proceedings at unfair sa mga complainants. And labag dun sa ating rules natin. Recital of facts constituting the offense charged. So what is the point of looking into or inquiring into the authenticity of supporting documents? That's my view, Madam Chair.
Thank you.
very
The
much.
Honorable Flores.
Madam Chair, I agree with Congresswoman De Lima, and I have also seen the complaint and the attachments for the impeachment complaint against the Vice President. And it's voluminous, Madam Chair. And if we follow that rule on that impeachment complaint, it will take us forever.
Madam Chair.
The Honorable De Lima.
Thank you very much, Madam Chair. In view of these views expressed post-voting, may I move for reconsideration of the decision of the majority?
For the guidance of all the members, the question of the committee right now is only with respect to whether or not the records are authentic. It doesn't go into the truthfulness of the contents of the attachments yet, which is evidentiary already, no? The motion which we voted upon only pertains to whether or not we will include the issue of authenticity of the attachments. And I think that will be answered by merely checking on whether they are certified or otherwise. We are not looking into the truthfulness of the contents of the attachments yet, because we all agree that that will happen during the hearing proper of this proceeding. So with the indulgence of all the members, we have voted upon this motion. This is merely preliminary. We have 5 grounds to discuss, 5 offenses anchored on 3 grounds to discuss. We shall now proceed to hear the comments and manifestation on the first ground. That is kidnapping and surrender of the former president constituting either culpable violation of the Constitution or betrayal of public trust.
Madam Chair. Yeah, sorry.
Is this about the first
No, it's
offense?
still about the annexes, Madam Chair.
We have ruled on that issue already. So,
Madam Chair, let's
in the
proceed.
interest of
Let's
time,
proceed.
in the interest of time and with the indulgence of all the members, let us proceed to hear the comments and manifestations on the offenses and whether the same constitute a ground for impeachment.
All right, I just wanted to state for the record, Madam Chair, that proceeding to the first ground,
The first offense.
the first offense, most of the annexes are news articles. I'm stating it for the record. They're only, for the entire complaint, there are only, I think, 3 annexes that are official records on which I'm asking on whether or not there exists a certified true copy for it when it was submitted to the House. No? So this is Annex U, transcript of Committee on Accountability of Public Officers and Investigations, Blue Ribbon, 25 September 2025. Annex L, Supreme Court decision dated 3 December 2025, Pimentel versus House of Representatives. And Annex A, Committee Report, Committee on Foreign Relations. Everything else, Madam Chair, are actually news articles that had been submitted as attachments to this particular complaint. And I think there is particular relevancy to it because I'm quite certain that it might be insufficient for evidence to be based on mere news articles only. So going to the allegation relating to kidnapping and arresting the president and bringing him to The Hague. I think it needs to be stated, Madam Chair, that the arrest of the former president is in pursuance of a treaty obligation between the Republic of the Philippines and Interpol. So, wala pong batayan para sabihin that the former president was kidnapped. More importantly, kidnapping is a legal conclusion and it does not constitute as a statement of fact. No? So, dun pa lang po, parang meron na pong problema yung pong ground po na ito. So, to be clear, ang annex po on the matter is Annex A, Committee Report, Committee on Foreign Relations. Annex B, Senate probe reveals lapses in Duterte's arrest. Daily Tribune, 27 March 2025. Annex C, Duterte ICC arrest. Inquirer, 27 March 2025. At Annex D, VP Sara on father's arrest. GMA News Online, 20 July 2025. But I think it has already been sufficiently established, Madam Chair, that this was not a kidnapping. This was an implementation of a warrant that had been issued by the Interpol, in which Interpol sought the assistance of the Republic of the Philippines to implement this particular arrest warrant against the former president. To be clear, this is not in pursuance of a relations between the International Criminal Court and the Philippines, because this relation has already been broken when we had left the ICC in the previous government. So, para malinaw lang po, walang batayan para sabihin na meron pong pananagutan ang ehekutibo dito po sa pag-aresto sa dating Pangulo at pagdadala po sa kanya sa International Criminal Court, Madam Chair.
Madam Chair.
The committee notes the manifestation of the Honorable Ridon. The Honorable Chu is recognized.
Thank you, Madam Chair. Madam Chair, I share the observation of the Honorable Terry Ridon, and I also submit that there is insufficiency in substance for a very simple reason that we all should be guided by the elements of the crime alleged, which is kidnapping. Ano po ba para pumasok sa kidnapping? Maliwanag naman po sa ating revised penal code. Number one, kailangan yung offender is a private individual. Dito pa lang po, wala na po, tapos na po yung usapin. Pangalawa, dapat po ay yung act, dapat po the act is illegal or the deprivation of liberty is without legal justification. Maliwanag naman po that the arrest of the former president was via warrant issued by the International Criminal Court. So dito pa lamang po sa dalawang elementong ito ng kidnapping, wala na po, kulang na po. Kaya masasabi ko po na yung offense charge will not be sufficient in substance. Thank you po, Madam Chair.
Madam Chair, may I
Thank
be
you.
recognized? Madam Chair.
The Honorable Po, and then Honorable Chel Jokno, and then Honorable De Lima. And then Honorable Vice Chair Dumogan.
Madam Chair, thank you for recognizing me. Just for clarity, would it be possible to ask the endorsers if they're aware of any kidnapping cases that were filed against any members of the administration in relation to the ICC arrest?
May we request the endorser, the Honorable Nisay, to answer the question of the Honorable Po?
Madam Chair, sagutin ko lang yung kabuuan. Attached sa DSUS complaints ang ilang dokumento o public records at pati na rin sa mga news articles kasi sila ang pinaka-accessible.
If I may interrupt, Honorable Nisay, the question is very specific. whether or not you are aware of a case of kidnapping filed against the impeachable official.
Am I aware, Madam Chair?
You are?
Aware of that.
So you are aware that there is a case of kidnapping filed against the impeachable official?
No. That there is no, ma'am.
Okay. So does that satisfy your question, Honorable Po?
Yes, Madam Chair. The reason why I asked that is because in order for us to determine that kidnapping had taken place to begin with, if there was kidnapping, shouldn't there have been a case filed against any administration official involved in the ICI arrest?
You mean not only the impeachable official?
Not only the impeachable official, because even if
Madam
we're saying
President,
responsibility-wise,
Madam Chair, the
shouldn't
President
the
is
case have
immune
been
from
filed?
suit, and therefore
That
there's
is
no
correct.
case pending before the President.
All right.
But Madam Chair, even if the President is immune from suit, no other official in the administration has a case pending regarding kidnapping.
Okay.
Am I
To
correct?
complete the question of the Honorable Po, he's asking if you're aware of any case filed against any government official in relation to the alleged kidnapping and arrest of the former president. Honorable Nisay?
Yes, Madam Chair, I am aware that no pending case.
He is aware that no cases were filed against any government official.
That's all, Madam Chair. Just wanted to establish that for the decision-making of those who will be determining substance on the grounds of kidnapping.
Thank you, Honorable Po. Honorable Jokno is recognized.
Thank you, Madam Chair. First, a point of clarification on the ruling of the chair and of the committee. Does this mean that during the next phase or the evidentiary phase of these proceedings, the complainants will not be able or will not be given the opportunity to authenticate their documents? Because I believe that that is a part of due process that should be accorded during the evidentiary phase. I am concerned because this ruling will have an effect on other impeachment complaints. Adhere to this and strictly apply it, that would we would be depriving complainants of their day in court. I'm very concerned about this, Madam Chair, because as I understand it, we go first through the form, which as Congresswoman De Lima said, is simply looking at the allegations of the complaint and hypotheticals of the complaint and hypothetically admitting that they are true. And then, and after, in our rules that require that all documents upon filing of the complaint already be duly authenticated.
The Honorable Vice Chair Dumogan.
Let us read Section 3 of our own rules. Second paragraph. Second paragraph. An impeachment complaint is verified by an affidavit that the complainant has read the complaint and that the allegations therein are true and correct of his personal knowledge or based on authentic records. There we are. The rules of the impeachment of the House requires that those documents to be attached must be based on authentic records. That's what I was pinpointing.
Madam Chair.
I might somewhat agree with you, but that is our own rules.
May I respond, Madam Chair? The way I understand it, that matter should have been taken up when we discussed the form, assuming it is sufficient.
The Honorable Tino.
In addition to that, I would point out that the requirement in the determination of sufficiency in substance, where it says that the complaint must be a verified complaint, meaning to say it is based on personal knowledge and or authentic records, that requirement is satisfied through the submission of a verification duly sworn to and notarized. So for purposes of these preliminary stages of the impeachment proceeding for as long as stages of the impeachment proceeding for as long as there is a verification duly notarized.
Authenticity of the attachments. As to the question of the Honorable Jokno, whether we will be allowing its authenticity during the reception of evidence, we reserve the discussion of that issue as we reach that matter, which is the reception of evidence during the hearing proper. We are reminding the members of the committee to confine the discussions and manifestations to the offense which is being discussed at the moment. We are on the first offense. On the first offense. The Honorable Padiernos.
Madam Chair, may I proceed to propound some clarifications and questions?
Is it on the first offense?
Yes, Madam Chair.
You may proceed.
I would like to address the questions to the Honorable Nisay. So, for clarity, the grounds for the first allegation is based on culpable violation of the Constitution and betrayal of public trust. Is that correct, Madam Chair?
The Honorable Nisay.
Of the culpable violation of the Constitution, which specific provision in the Constitution did in this case, the President violate?
Representative Nisay may answer. The question is the specific provision of the Constitution which was violated by the impeachable official.
Yes, Madam Chair.
Madam Chair, can request 2 minutes break.
By our understanding about the sufficiency in substance, that the offense alleged we should be able to, Constitution was actually violated in relation to allegation of the kidnapping and arrest of the former president.
Determine whether there's a recital of facts constituting the offense charge.
Po the due process, nirerespeto po natin yung Constitution.
May we know from the endorser that whether any Philippine court has issued a finding that there was a violation of due process or that the arrest constituted kidnapping? So in this case, Madam Chair, it would appear that on the basis of the first ground, there is no impeachable offense. And to add on to that, Madam Chair, may we know from the endorser whether there is an actual written presidential order with regard to the arrest of the former president.
Madam Chair, wala po pero
Congressman Padiernos, he's saying that the PNP was under the directive of the impeachable official, that's why. Notwithstanding lack of order coming from the President.
But again, Madam Chair, we are determining here there must be an overt act personally attributable to the President or the impeachable official. So how can we say that the impeachable official should be liable because of the supposed action of the PNP in this case?
Honorable Nisay, Honorable Padiernos is asking for the overt with regards to the alleged arrest and kidnapping.
Madam Chair, I think yung dapat po na wala siyang ginawa. Yun po yung
So, Madam Chair, is omission equivalent to an impeachable offense? I would just like to manifest that based on the answers propounded by the endorser, and with due respect, this representation does not believe that there is an there is a recital of facts that would constitute the offense charge being culpable violation of the Constitution and betrayal of public trust. That's all,
The
Madam Chair.
committee notes the manifestation and answer of the endorser.
Madam
The Honorable Suntay.
Thank you, Madam Chair. Through you, Madam Chair, on the first ground, alleged culpable violation of the Constitution, the complainant alleges that the President ordered or enabled the arrest of and surrender of the former President Rodrigo Duterte to the ICC, did so without a valid Philippine warrant, therefore violating national sovereignty, due process, and constitutional guarantees. Would that be correct?
Yes, Madam Chair.
So the legal theory asserted, Madam Chair, is that the ICC surrender constitute a constitutional violation and therefore an act of betrayal of public trust. Would that be correct?
Yes,
Honorable
Madam
Nisay.
Chair.
And may I know, Madam Chair, through you, may I know what would be the evidence to support these allegations? I was reading the complaint. I saw Senate committee reports, media articles, statement of public officials, and it was limited to that. Would there be any other?
Madam Chair, yung mga news articles, yung mga publicly available published articles. Kasi sila po yung pinaka-accessible na form ng public record na nag-reflect ng mga event timelines at statements na alam naman ng public. Kanina, isa sa mga layunin ng mga news articles na ito ay mag-establish ng pattern na mayroong nangyayaring graft and corruption, culpable violation of the Constitution, betrayal of public trust. Kumbaga sila ay mga circumstantial evidence na pag nag-combine ay magpo-form sa conclusion na karapat-dapat nang impeach ang ating presidente dahil siya ay karapat-dapat hindi mamuno.
So, Madam Chair, through you. So, based on your answers on the first grounds being alleged, the only evidence are news articles and clippings. Therefore, you are attributing these actions to the President. Are there any arrest orders signed by the President?
That question has been answered already, Honorable Suntay.
Executive issuances or documentary proof of direct command?
Madam Chair, wala po.
So, does that mean that we are alleging a constitutional offense committed by the President just because the former President was, the ICC was allowed to not arrest, because to try the former President?
Yes po, Madam Chair.
So, Madam Chair, based on the answers of the endorser, on the first ground, my position is that the allegations is not sufficient to form an impeachable offense on the first ground.
Okay. For the guidance of the members, we need not state our position with respect to the sufficiency. All the questions, manifestations, and comments will be taken in consideration as we vote on the entirety of the impeachment complaint with respect to the sufficiency in substance. Nonetheless, the position of the Honorable Suntay is duly noted by the committee. The Honorable Po and then the Honorable De Lima. Is this still on the first offense?
First offense, but wrapping
You may
up.
proceed.
Madam Chair, on the first offense, just to give clarity to everything that we've spoken about at the moment,
Kindly speak louder, Honorable Po.
just to give clarity on what was taken up so far, the endorser is claiming that there is a betrayal of public trust based on kidnapping, which, as we've discussed here, no cases have been filed, on a violation of due process, again, in which no cases have been filed, because of command responsibility in which the PNP was acting under the President. Again, no cases were filed against any member of the PNP for either a lack of due process or for kidnapping. So just for the members of the committee who are deciding on this matter, on the substance of the first grounds, it would be important and prudent to note that there are no cases filed as attested to by the endorser. And if our determination of betrayal of public trust is based on kidnapping, which wasn't affirmed, and betrayal of due process, I feel that this may be something we should take a closer look at, and maybe we should wrap up already on this discussion and move on to the next grounds.
Madam Chair.
The Honorable De Lima.
Thank you, Madam Chair. So we're talking about the first ground. The general ground, the general ground is culpable, or the ultimate ground is culpable violation of the Constitution and betrayal of public trust. The supposed supporting factual allegation is ordering and enabling the kidnapping and surrender of the former president to the ICC. Now, for this specific factual allegation, I point out 3 sub-allegations. One is that the former president was arrested without Philippine warrant and forcibly transferred to ICC. I say that these are insufficient allegations of facts in terms of time and date, place of occurrence, persons involved, and events that transpired. Complainant, I humbly submit, cannot presume judicial notice of sequence of events that transpired in the former president's arrest. He must allege the specific facts of the arrest relevant to this ground of impeachment, and not merely a general allegation that the former president was arrested and transferred to ICC. The second sub-allegation is that allegedly PBBM resorted to foreign intervention and ignored domestic legal processes. I say that these are legal conclusions and not allegations of fact. Even if this is to be treated as factual allegations, complainant must state the specific acts laying down the conclusion that PBBM resorted to foreign intervention and disregarded domestic processes. The complaint must answer the question of what were the specific acts committed by PBBM that constituted consenting to foreign intervention and disregarding domestic legal processes. Again, the complaint cannot presume judicial notice of the events that transpired on that day. The third, the last sub-allegation of fact. PBBM surrendered the former president, FPRRD, to a foreign tribunal. I say again that this is a legal conclusion and not an allegation of fact. Even if this is to be treated as a factual allegation, the complaint must still allege the specific acts, that constitute the surrender of FPRRD to a foreign tribunal. Complaint cannot rely on judicial notice to establish the specific acts that constitute surrender to a foreign tribunal, which is in fact also debatable, especially in light of alternative versions that FPRRD was not surrendered but arrested by virtue of an ICC warrant in accordance with RA 9851. So to me, Madam Chair, the first allegation is not a sufficient allegation of fact, but mere conclusions lacking in specificity. So insufficient po para sa akin yung first ground.
Madam
Thank
Chair.
you.
Thank you, Honorable De Lima. Now we recognize the Honorable Alvarez.
Given the lengthy discussions, listening to legal luminaries
On the first offense.
of the first event of the complaint, even given that the president was there during the planning of the execution to serve the warrant, even if he committed error in judgment, is not an impeachable offense. Therefore, given that the first complaint on the Jesus complaint has no substance, Madam Chair, I move to dismiss the first complaint.
We are not
the
finished with our discussion of the offenses and as to whether they constitute an impeachable ground.
Therefore, I modify my motion to consider the first allegation as insufficient in substance.
Madam Chair.
We cannot entertain that motion as well because we will be deciding on the entirety of the complaint after we have deliberated upon the 5 offenses alleged in the complaint. Nonetheless, the manifestation of the Honorable Alvarez is duly noted.
Madam Chair.
Any other
Madam
manifestation,
Chair.
Honorable Alvarez?
I maintain my motion subject to further deliberation of this committee, Madam Chair.
The motion is considered as the manifestation by the Honorable Alvarez.
Madam Chair.
The Honorable Rodriguez, then Garbin, then De Lima.
Thank you, Madam Chair. I'd like to ask propound questions to the endorser, the Honorable Jet Nisay. Are you aware that there is an international organization called the Interpol, International Police, Criminal Police Organization, which was created in 1956 by the United Nations, by the General Assembly in 1956, and the Philippines is an original founder and signatory of this convention.
Yes, Madam Chair.
And of course, you're aware that the ICC has issued a warrant and it requested the Interpol, the international organization, wherein we are members, to cause the arrest of the former president in the Philippines.
Yes, Madam Chair.
So the arrest is not based on the order of the president or anybody in this country, but it is pursuant to an implementation which we are duty-bound to therefore cause the arrest of the former president because the ICC has issued a warrant of arrest. Would you agree with that?
Do you? Madam Chair, dapat po yung position natin dumaan sa judicial system muna natin.
But Rule 59 of the Rome Statute of the International Court of Justice precisely provides for the arrest. Now, you go to the court. That is also provided in the Rome Statute. And that's why there's also an issue on the rendition, because you stated here surrender. And of course, that's another issue. The first issue is the arrest. And clearly, the arrest is legal because it is upon our compliance of international law. Now, so the rendition, there are many views. And would you therefore agree that this particular issue is now in the matter of, for the record, Madam Chair, in the matter of the petition for habeas corpus of Rodrigo Roa Duterte, petitioner Sebastian Z. Duterte, against the Honorable Lucas Bersamin, it is GR number, to put on record, the number, Madam Chair, is 278-73,
And the other cases brought about by Veronica Duterte and also by Paulo Duterte, which in seriatim was also filed, cases of these cases are the following. It is stated here in the prayer. It is questioning the arrest and the surrender of the president to the International Court of Justice. Are you aware of that? International Criminal Court.
Yes, Madam Chair.
So therefore, with your answers, the Honorable Jet Nisay, then there is no kidnapping, because kidnapping means that there is no power of any person to be able to get into detention a person. And therefore, in this case, there's a warrant of arrest. And it was executed by our country, which is a signatory to the Rome Statute. And as to the issue of rendition, surrender, it is already the Supreme Court, and according to our rules of judice, we cannot discuss here cases the Supreme Court. Whatever we say here, once the Supreme Court comes out with a decision on these cases, on the validity of the arrest, of the bringing of the president, the rendition to the ICC is a matter already in the Supreme Court. You agree with that, Mr. Jet Nisay? These are facts. You are stating here that there is kidnapping, there is illegal surrender, but the facts are that precisely Interpol, arrest. Rendition, the issue is in the Supreme Court. Would you agree with that?
Yes, Madam Chair.
Thank you.
Pero
Madam Chair.
ganun din pa, may-
I wish to remind the House members, the committee members, that if you can express your point by way of manifestation instead of question, we will encourage that. That is in the interest of time, because we have 4 other offenses to deliberate upon. Now we will move to the recognition of the Honorable Garbin.
Thank you, Madam Chair.
Let us all be reminded that this is just preliminary. The endorser will be very much ready to answer all the exhaustive questions when we reach that hearing proper of our proceedings. So kindly limit our question, and if you can translate it into manifestation, that would save a lot of time. Thank you.
Madam Chair, on the first allegation, culpable violation of the Constitution, the endorser alleged that, or avers that, he based his allegations grounded primarily on media reports and public documentary. Culpable violation of the Constitution, in the records of the deliberation of the Constitutional Commission, defined as willful and intentional violation of the Constitution. Commissioner Mambong, I'm referring to the records of the Constitutional Commission, stated that culpable violation of the Constitution means willful and intentional violation of the Constitution, and not violation committed unintentionally or involuntarily or in good faith or through an honest mistake of judgment. How can we decide on sufficiency primarily based on media reports and public documentary? In fact, I refer to the case referred and mentioned by Congressman Rufus Rodriguez in the case of petition for writ of habeas corpus of Rodrigo Roa Duterte. It's still pending before the Supreme Court. And the House, and that is precisely the reason why there is a pending case before the Supreme Court regarding the legality of the arrest, and to render it illegal at this point and attribute the same to the President is still premature and baseless, Madam Chair. The House will then be placed in a very awkward situation wherein a President is being tried for a supposed illegal arrest when the same is subsequently ruled as legal. So I therefore submit that manifestation, Madam Chair. Thank you.
Madam
Thank
Chair,
you.
point of order,
Thank
Madam
you.
Chair.
before we proceed, we've heard a lot of opinions, comments, and even questions from the members with respect to the first offense. So it is the intention of the chair to limit the succeeding members who will be asking on this offense so that we can move to the next offense. Nonetheless, we recognize the Honorable SDML Lawrence Defensor.
Madam Chair, just a point of order on the way we proceed with the deliberations. Let's just address our manifestations as the complaint alleges. We don't have to interrogate the endorser. The Honorable Nisay is not the complainant. Let's just make manifestations and simply state the complaint alleges the following and state our manifestation. Thank you, Madam Chair.
We encourage the committee members to follow the suggestion of the Honorable SDML Lawrence Defensor. The Honorable Vice Chair Dumogan.
Thank you, Madam Chair. Pursuant to the instruction of the Chair, and has already been suggested, let me manifest that on ground one, there's no impeachable offense. We all know that there's no kidnapping. Second, the arrest was by virtue of an arrest warrant issued by the International Criminal Court because of an offense which had been allegedly committed when the Philippines was still a member of through the Interpol. So, and let me point out, with all due respect, look, there's actually no narration of facts. It just stated and went to the arguments. So, I am forced to, of course, manifest that the respondent did not culpable violation of the Constitution with respect to allegation number one. I so submit.
Thank you, Vice Chair Dumogan. With that, judgment and leadership. This is anchored on the ground of culpable violation of public trust. At this juncture, we elicit the manifestations of the committee members with respect to its sufficiency in substance.
Madam Chair,
The Honorable Agbas is
to
recognized.
serve as president due to drug addiction, it fails to allege the ultimate facts, showing how this alleged personal condition translated into any impeachable act. It does not narrate when the alleged use occurred, how it was committed, or how an impeachable offense. Further, no factual narration of an official decision, directive, or exercise of presidential power impaired by, connected to, or caused by the alleged addiction. That's all, Madam Chair.
Any other member who wishes to make a manifestation on this?
Madam Chair, may I be recognized?
The Honorable Barbers, and then De Lima, and then Suntay. One after the other. You are recognized, Honorable Barbers.
Thank you, Madam Chair. A manifestation. One of the grounds stated in the impeachment complaint filed by Attorney De Jesus and endorsed by Representative Nisay is the allegation that the respondent is a drug addict whose condition impairs his allege in his complaint that the respondent's refusal to submit to drug test conclusively demonstrate his disregard for transparency and accountability, and concluded that the respondent's silence and evasion confirmed the public suspicion and betrayed the trust of the nation he swore to serve. Madam Chair, let me point out that this assertion in the complaint was based solely on the alleged statements of the sister of the respondent, Senator Amy Marcos. The complainant attached copies of news articles containing reports on such statements of Senator Amy Marcos and forms part of the complaint. It's a procedure and in impeachment proceedings, the requirement of sufficiency in substance is met if there is a recital of offense charge and determinative of the complainant. That will support his allegation that the respondent is actually using illegal drugs. The complainant did not even mention that he has personal knowledge of the drug addiction of the respondent. Such allegation of illegal drug use who filed the complaint and that his refusal to submit to drug impeachment of the respondent on his alleged drug addiction that impairs his judgment and leadership is insufficient in substance. Thank you, Madam Chair.
The manifestation of the Honorable Barbers is noted by the committee. The Honorable De Lima.
Thank you, Madam Chair. This is actually supplementary or complementary to the manifestation made or the opinion made by the Honorable Representative Barbers. The ultimate general ground, betrayal of public trust. The specific allegation is alleged drug addiction of the President. And again, I would point out to certain sub-enemies claim of PBBM's addiction, PBBM's refusal to submit to a drug test, and his silence on accusations of being an addict still do not constitute the factual allegations necessary to satisfy the legal exercise. Another sub-allegations is the PBBM is a drug addict because he refuses to submit to a drug test. Again, this is a conclusion and not a factual allegation. Nasabi ko na rin po, that kind of an allegation is still insufficient. The fact that he refuses to submit to a drug test. Another is by being silent. Chair, this is a non sequitur conclusion and not a factual allegation. Because the ground must not only state a categorical allegation that PBBM is a drug addict and that this impairs the performance of his mandate, but must also include a recital of the alleged acts, events, and incidents that support the same. How do they say, or how do they know, or why do they claim that it impairs his judgment? So that's again my view. Again, this second ground.
On the second ground, alleged unfitness due to drug addiction, President Marcos is alleged to be a long-time user of illegal drugs. Drug use allegedly renders him manifestly unfit to discharge his presidential powers. The evidence presented were public statements attributed to Senator Amy Marcos, news articles, opinion commentaries, and medical articles on the effect of cocaine use. Thus, the legal theory asserted is that drug addiction impaired his judgment to discharge his presidential duties. However, this is a general conclusion because there was actually no narration of which of the presidential actions or judgment was impaired due to the alleged drug addiction. There was also no medical evidence presented, no drug test results. So the allegations were merely limited. The evidence of drug use were merely limited to media reporting and political statements made by Senator Amy Marcos. In Philippine impeachment jurisprudence, it has never recognized personal health allegations without proof of impeachable offense, of the impeachable offense. And with regards to the second complaint, there were actually no general, there were actually no evidence, actual evidence presented to justify the allegations.
You are referring to the second offense.
Yes, with regards to the second offense.
Thank you.
Madam Chair.
Honorable Garbin first, then Honorable Po. Honorable Garbin, you are recognized.
Thank you, Madam Chair. On the alleged drug addiction and the key factual allegations by the complainants were the President is accused of being a long-time user of illegal drugs, including cocaine, and central reliance is placed on public statements by Senator Amy Marcos, the President's sister, alleging or acknowledging his alleged decades-long struggle with illegal drug use. And the legal framing of the complainant is that not framed on any criminal accusation, and it is used to support the moral and fitness, the impaired judgment, and the betrayal of public trust. The allegation that the President is a drug addict is insufficient in substance. It is unsupported by competent evidence, such as medical findings, sworn admissions, or official investigation on record, and rests largely on hearsay and publics or misconduct indirectly related cannot establish impeachable offense and should not be given weight, Madam Chair. Thank you.
Po and Kong Lord and Suwan, we encourage the other members to participate in the discussion of the succeeding offenses.
Madam Chair, can you add me for the...
No existing record of any drug abuse. The President has on 2 occasions proven that he is not a drug user. I submit that to the record so that we can make a objective decision on the substance of the second ground.
The manifestation is noted.
Section 28 of an act of one cannot prejudice another, meaning that the so-called admission of Senator Amy cannot prejudice the President, which means that the so-called admission has become irrelevant and cannot be considered as one of the bases for sustaining sufficiency.
Morgan. We encourage the rest of the members to participate.
But a conclusion of fact not based on any evidence. There is no evidence that the President is using drugs. Only statements of some persons. And then, this particular allegation, being a mere conclusion, does not connect to any of the 6 grounds of impeachable offenses. And so therefore, clearly, this particular second act complained of has certainly it's not sufficient in substance. Thank you, Madam Chair.
Thank you. The manifestation is noted. Vice Chair Dumogan.
Thank you, Madam Chair. In addition to what already been said, which I fully agree, not somewhat come up, a culpable violation of the Constitution being a drug.
And as mentioned by the Honorable Suwan, the res inter alios acta rule apply. So, and in addition, personal allegation. That's it, Madam Chair. Thank you.
That ends our discussion on the second offense. Now we are moving to the third offense. Please let the chair read and progress of the General Appropriations Bill for 2023, 24, 25, and 26. The same is anchored under either some or all of the following grounds: graft and corruption, culpable violation of the Constitution, and betrayal of public trust. At this juncture, we elicit the opinion, comment, reaction of the members to this allegation.
Madam Chair.
The Honorable Amben Amante.
Yes, about the unprogrammed funds. Dala din ito ng ating gobyerno yan sa unprogrammed appropriation or sa under papagawa do sa mga naturang mga infrastructure project. Dahil expressway, just because of the earthquake, hindi naman pwedeng aantayin yung susunod na taon para maipagawa ito dahil maraming nakikinabang. So, ayun lamang po, Madam Chair, yung ating komento about the unprogrammed funds. At I don't think na kinakailangan ibito ito ng ating mahal na Pangulong Bongbong Marcos.
Thank you. The manifestation is noted. Any other comment?
Madam Chair.
The Honorable Emeng Pascual.
Yes, Madam Chair, the inclusion of unprogrammed appropriations in the national budget has been practiced since 1989 up to the WH. Yun lang po. Thank you, Madam Chair.
Thank you, Honorable Pascual. Any other member who wish to comment on this?
Madam Chair.
The Honorable Erice, and then Honorable Acosta, and then Honorable De Lima, one after the other. And then Honorable Rodriguez. Honorable Erice, you are recognized.
Madam Chair, I think the issue of the 2023, 2024, and 2025
budget and the program appropriations and other items that has been questioned even by the nakaalaman, yung complainant tungkol dito. Kaya po hindi po niya naipresenta ng maayos yung batayan lamang yung mga news articles. Kaya sa tingin ko po ay hindi sapat yung substance ng complaint na ito. Salamat po.
Thank you, Honorable Arice. Next is the Honorable Acosta.
Thank you, Madam Chair. Just 2 points. First is on the veto power of the President, Madam Chair, that the power of the President to veto bill or specific items in an appropriations bill under Article 6, Section 27 is a discretionary power, not a mandatory duty. Jurisprudence dictates in that landmark case of Bengzon versus Drilon establishes that the President cannot be compelled to exercise a veto. Therefore, Madam Chair, a failure to veto cannot be a definition or a culpable violation of the Constitution. Second is on the attachment on paragraph 25, on that case of Pimentel et al. Versus House of Representatives, Colmenares versus Executive Secretary, GR numbers 27477, culpably violated the Constitution by signing it. If it were the case, Madam Chair, that every president who signed law was later voided would be impeached. There must be proven bad faith, which the complainant fails to allege in this instant, Madam Chair. Thank you po.
The manifestation of the Honorable Acosta is noted by the committee. Next is the Honorable De Lima.
Thank you, Madam Chair. As to this third ground, the specific ground of failure to veto unprogrammed appropriations and other provisions of the 2023 of public trust. My view, again, is that these are insufficient, or this ground is insufficient in substance. Again, there are three, I point to...
Honorable De Lima, because we do not want to miss your valuable opinion on this, kindly speak closer to the microphone.
Thank you, Madam Chair. So this specific ground has, again, three sub-allegations that I see from the face of the complaint. Number one, PBBM did not veto unprogrammed appropriations. There is lack here of specification of how the alleged omission was committed other than a general averment and the provision of law or constitution violated in the omission. Number two sub-allegation, PBBM wanted to preserve discretionary control over public funds. It lacks specification of the acts committed and the provision of law or constitution violated. The third sub-allegation, PBBM subverted the power of the purse and violated the Constitution when he did not vote. This is a conclusion of law and not a factual allegation. So all of these allegations under this third ground fail to establish the nexus between the alleged failure to veto unprogrammed appropriations and betrayal of public trust. This ground does not go further than argue that because PBBM did not veto unprogrammed appropriations, therefore he betrayed the public trust. Well, we know that with respect to the general ground of betrayal of public trust, there is much leeway because this is supposed to be a catch-all provision, like a culpable violation of the Constitution, unlike the others like treason, graft and corruption, and bribery, wrongdoing, or failure of judgment. Now, this conclusion must be preceded by a recital of factual allegations establishing why exactly PBBM's refusal to exercise his veto power on unprogrammed appropriations amounts to a violation of the law and the Constitution. Personally, Madam Chair, along with the Honorable Chair Egay Erice, I always held the view that unprogrammed appropriations in the budget are of questionable constitutionality. That's why we filed a petition before the Supreme Court. But the issue here is not alleged on the face of the complaint has a connection or can satisfactorily establish betrayal of public trust. As I said again, these are mere conclusions and therefore insufficient. Thank you, Madam Chair.
Thank you, Honorable De Lima. Now we
Madam Chair.
recognize the Honorable Rodriguez. Honorable Rodriguez, then Honorable Chua, then Honorable SDML Defensor.
Thank you, Madam Chair. Manifestation very short. Again, this particular third act does not constitute, it does not have comply with the requirement of sufficiency in substance because the President has that discretion to veto or not. If it's veto, that's the end. You try to have it again, probably convince the President the next time to veto. If it's veto, the only solution is not even the committee. It goes back to Congress to override it. And the problem here really is the connection and the support to the allegation that culpable violation of the Constitution. You have to show which section of the Constitution is violated. Number two, treason. That's Article 210 of the Revised Penal Code. Committed only in times of war. Third is the a case of bribery. That's 114 of the Revised Penal Code, direct bribery, knowingly receiving. And then the fifth is other high crimes. American have no. And to me, there is a failure of the narration of facts to say that the failure to veto of unprogrammed appropriations will be a betrayal of public trust. That's so far from this title of this act to the constitutional requirement that there should be betrayal of public trust. So therefore, that is my manifestation. Again, no substance in this case. Thank you.
Thank you, Honorable Rodriguez. Now we recognize the Honorable Joel Chua.
Thank you, Madam Chair. Madam Chair, the third issue relies solely on the failure of the President to veto the unprogrammed appropriation. So yung pag-veto lamang po ang kino-question niya po dito. But we know for the fact that the veto power is the exclusive prerogative and power of the President. Not even the President, not only the President, Governor, they all have this veto power and that is exclusive. Hindi rin po naka-state dito sa fact na to kung bakit ito, kung ano pong crime ang na-violate ng Presidente sa kanyang failure sa pag-veto ng nasabing unprogrammed appropriation. That's why, Madam President, Madam Presiding Officer, the third ground, I believe, does not or is not sufficient in substance.
Thank you, Honorable Chua. Next is the Honorable SDML Lawrence Defensor.
Thank you, Madam Chair. To veto or not to veto is a political question, which was clearly stated by the Supreme Court in the case of Tañada versus Cuenco, that political questions are those questions which, under the Constitution, are to be decided by the people in their sovereign capacity, or those which full discretionary power has been delegated to the executive or the legislative department. The exercise or the non-exercise of that power by the President when it comes to the national budget is a non-impeachable offense. So therefore, let's move on to the next offense, Madam Chairman.
Madam
Thank
Chair.
you. Now let us recognize the Honorable Suntay.
Thank you very much, Madam Chair. On the third ground, on the failure of the President to exercise his veto power, the legal theory asserted is that his failure to veto unconstitutional provisions is tantamount to betrayal of public trust. The evidence cited were Supreme Court rulings voiding certain budget provisions, DBM documents, and news reports. However, as we all know, the presidential veto power is discretionary to the one wielding it. It is his prerogative to use it or not to use it. If he chooses not to use it, it is not an impeachable offense because it is discretionary upon the person holding it. It is also not the constitutional. It is also not a constitutional duty to veto every unconstitutional provision because we have to first determine which provisions of the budget of the GAA is unconstitutional. And at that time, there was no determination that the provision was unconstitutional. So, thirdly, we cannot impute culpability on his failure of not using it because it requires proof that there was bad faith and corrupt intent. That's why the President did not use irrigation.
Thank you, Honorable Santay. The Honorable Tino.
Thank you, Madam Chair. Madam Chair, I agree with some of the positions expressed here that in this case of the third act, under discussion, what is in question is the exclusive discretion of the President to veto, the veto power of the President. And the allegation here is that that veto power was abused. Okay, now abuse may be done through a positive act or also through inaction when discretion is required. So, in the case here, one allegation is that the President failed to veto unconstitutional provisions. Now, it may be the case that there are certain provisions in the budget that are blatantly unconstitutional or illegal, in which case the President precisely has been given the veto power in order to address that. And if you read the presidential veto messages by the President explaining that this particular special provision approved by Congress will be in conflict with existing laws. Therefore, it is vetoed. No? So therefore, tama lang po. Pwede pong maging ground for impeachment yung hindi pag-veto. Lalo pa kung talagang lantad na illegal ang provision na yon. No? For example, unprogrammed appropriations may be sourced from PhilHealth funds. Okay? That is blatantly unconstitutional because there is a syntax law. Okay. However, that the President failed to veto unconstitutional provisions in multiple national budgets. However, the complaint does not specify which particular provisions are unconstitutional and required veto. So there is merely a general allegation.
Since we have to take into consideration that this has substance, then we are admitting or we are taking away from the willful action that must be provided if we're to see grounds for impeachment. What's important to note here is that if we say that the President was lacking in his duty because he did not exercise...
The Honorable Vice Chair Dumogan.
Thank you.
Our last speaker on third offense.
Thank you, Madam Chair. In addition to what had already been said, which I fully agree, let me point out that the budget which the President failed to... The President, if he did not exercise his discretionary power to veto what had been passed by both houses of Congress, on that score alone, I do not think that it can be considered as illegal violation which is tantamount to culpable or willful violation of the Constitution on the ground of betrayal of public trust or corruption.
That ends our discussion on the third offense. The committee acknowledges all the significance. Please allow the chair to read. Respondent benefited from kickbacks arising from budget insertions and ghost flood control projects. At this juncture, the chair elicits the comment.
Madam Chair.
Mag-walk out ka uli.
Hindi na.
The Honorable Abante is recognized.
Usapan ngayon eh. Kaya kasama na rin ako dito.
But anyway, ito pong fourth allegation. Isa lang sabihin ko dito. Nakalagay po sa ating rules, if it finds that sufficient grounds for impeachment do not exist, the committee shall dismiss the complaint and submit the report required hereunder. Ito po, it does not actually exist because everything that is said here is hearsay. Yun lang po.
Thank you. The Honorable Rodriguez.
Madam Chair, in this fourth act, which is alleged, it is clearly based on the fourth ground of impeachment, which is Graft and Francisco versus House of Representatives, clearly already said that this is defined under the Republic Act 3019, which is the anti-graft code, the anti-graft law, which provides Section 3B and C. These are the main, if this is an allegation of a public official who receives kickbacks and from ghost projects and so forth, it should be under this. And it is clear, Madam Chair. We have to therefore go whether there's a recital of facts in relation to, Madam Chair, Section 3B and C. And here we go. This is now what it says, Madam Chair. It says Section 3A, knowingly, deliberately, requesting and receiving money because of an important project or permit to be issued by the person. There is no allegation here, Madam Chair, that the President requested, that the President received money because he has a permit or contract to give. That is precisely what is stated here under Section 3A. Directly or indirectly requesting or receiving any gift, present, share, percentage, or benefit for himself or for any other person in connection with any transaction or contract between the government and that party. The second one, 3C, also is directly or indirectly requesting or receiving any gift and so forth for himself and another in a manner or capacity that has secured or obtained 3019, wherein, according to the Supreme Court, the fourth ground could be anchored upon, and there is no allegation here. Now, there is a statement here about Ako Bicol party list. This is a narration of fact, the recital of fact. However, the problem with this fact is that it was delivered to respondents' allies. If you can look at this, not to the President. Now, this is an impeachment, proposed impeachment of the President. And then attached copies of the video expose. Madam Chair, the video expose is abroad, wherein we, in the later part, will have to hear this particular person has to be present. Otherwise, it's a piece of paper and a piece of video that is not allowed to be introduced in any proceeding. Because we have to give the chance to the respondent to question always. This is the cross-examination. This is the time to also provide the respondent the time to question, cross-examine the person who said that the money was given and he is not in this country. He's either in Portugal or Sweden. And so therefore, Madam Chair, once again, the fourth ground, which is respondent engaged in graft and corruption through kickbacks and ghost projects, there is no recital of facts that will constitute the violation of the Republic Act 3019. Thank you, Madam Chair.
Madam Chair.
That is a significant discussion on graft and corruption. And of course, we recognize also the needed authenticity about the video of this expose. The Honorable Vice Chair Dumogan.
Thank you, Madam Chair. Yes, on allegation number 4, respondent engaged in graft in corruption through kickbacks and ghost projects. The allegations which seem to justify the said charge are contained in paragraphs 27 up to 32. Reading all these paragraphs, they do not contain the narration of facts that will pinpoint to the President, that will somewhat allude an illegal violation which is tantamount to graft in corruption. What had been stated here are allegedly given to certain allies. It's too vague and too wide to consider. So, looking at all of these allegations, clearly it does not justify the ground, again, to impeach the President on graft in corruption under the provision of Article 10, Section 11 of the Constitution.
The Honorable Acosta, the Honorable De Lima, and the Honorable Colliantes, one after the other. The Honorable Acosta is recognized.
Thank you, Madam Chair. This is just a reiteration of my two senior compañeros, cash and ghost flood control projects. But Madam Chair fails to provide one, specific dates, two, specific persons involved, three, specific project names, and lastly, involvement in this case. Madam Chair, it is my humble opinion that these are generalities and broad generalizations, which, according to the Supreme Court, in that case of Gutierrez versus House of Representatives, GR number 193459, are insufficient for impeachment, Madam Chair. Thank you.
Thank you, Honorable Acosta. Next is the Honorable De Lima.
Thank you, Madam Chair. As to this fourth ground, general ground, graft and corruption, and the main specific allegation that allegedly the President benefited from kickbacks arising from budget insertions and ghost flood control projects, with 4 sub-allegations. 1, PBBM orchestrated insertion in GAA for kickbacks. I agree with the Honorable Acosta that it lacks specificity as to what, how, and when, making this a conclusion rather than a factual corruption was not established due to the lack of specificity of the allegations in how PBBM orchestrated the flood control scam. For sub-allegation number 2, suitcases of cash were delivered to PBBM's political allies. Again, lacks specificity as to who, what, how, and when. Sub-allegation number 3, the ghost flood control projects confirm plunder of public funds that is not possible without PBBM's approval. This is a conclusion rather than a factual allegation. The fourth and the last sub-allegation for this ground is PBBM is allegedly the central figure in corruption schemes. This is again a conclusion rather than a factual allegation. In all of this, in light of the evidence uncovered, I just wonder, in light of the evidence uncovered in the multiple fora investigations conducted on the flood control scam, medyo kapos talaga sa allegation yung complaint. It seems overly complacent for the complainant to be sparing in his factual allegations as to establish the ground for impeachment. For me, Madam Chair, there is simply paucity of factual allegations. Again, this is insufficient.
Thank you, Honorable De Lima. Our last speaker on the fourth offense is the Honorable King Colliantes.
Madam Chair, I'd just like to manifest my support for all of the comments said by our dear colleagues. But really, the question right now here is, are these just conclusions made by the complainant, or are these really based on fact? Remember, we have to go back to the verification, which says that all of his allegations must be based on personal knowledge. Does the complainant have personal knowledge? Was he there when these alleged transactions happened? Does he have any basis based on authentic records to say that money was transferred, money was provided to the president? I doubt it. So I think based on what is written on the complaint, it is insufficient as a ground for impeachment. Thank you, Madam Speaker.
Thank you, Honorable Colliantes. That concludes our discussion on the fourth offense. Now we are moving to the fifth offense. Please allow the chair to read. Respondent, graft and corruption, culpable violation of the Constitution, and betrayal of public trust. At this juncture, we elicit the comments and opinions of the committee members. First, we recognize the Honorable SDML Lawrence Defensor.
Thank you, Madam Chair. I would have to speak. I'm compelled to speak for the membership of the ICI regarding this allegation that it was created to of the members of the ICI, particularly Secretary Rogelio Singson, whose integrity and reputation speaks of good governance, contravenes the allegations by this impeachment complaint head-on. Hindi ka maglalagay ng mga taong naging ehemplo ng mabuting patakaran at pamahalaan kung ang balak ay pagtakpan ang korupsyon. So the membership itself of ICI, a presiding justice of the Court of Appeals, an SGV partner who is a partner on audit, and someone like Rogelio Singson, who is a model for good governance, clearly runs contravene against this allegation in the creation of the ICI. Thank you, Madam Chair.
Thank you, Honorable SDML Lawrence Defensor. The Honorable Franz Legaspi is recognized.
Thank you, Madam Chair. I'd just like to give a very short manifestation to take note of the evidence or the annexes presented, the evidence in the annexes presented. For me, and this is a general observation as well with the earlier topics, but in particular for this ground, there are a lot of evidences the sources are only media outlets, news sources, and I think this was generally already noted by our members of this committee. But in this particular ground, these articles are, I think, 4 opinion columns, mostly predicated on the opinions of certain personalities, certain characters. And I think in relation to the particular ground that the complaint wishes to state, I believe I think it's clear the betrayal of public trust with regard to the creation, or rather the ICI's creation, somehow affecting or resulting in a loss of public trust, which would, in this case, be a ground to impeach the president. I think it's very clear on that part that the trust ratings are affected by the creation of the ICI. So that's my humble submission, Madam Chair. For me, I think this is, just based on this ground is already insufficient in substance as well. So thank you, Madam Chair.
Thank you, Honorable Legaspi. We are on the last offense. This is the allegation that the creation of the ICI is used to shield the allies of the impeachable official. The Honorable Vice Chair Dumogan is recognized.
Thank you, Madam Chair. Again, it appears that this is one of an allegation that is not at all supported by narration of facts. In fact, as we all know, aside from what had already been stated, the integrity and competence investigated all those that had come to their attention related to corrupt implementation of projects, which clearly disprove the allegation that it has been created to shield certain allies in government. So it's far, far away from establishing a legal violation which is considered as willful violation of the Constitution as an impeachable offense. Your Honor, thank you, Madam Chair.
Thank you, Vice Chair Dumogan. Any other comment or manifestation from the members? The Honorable Po.
Madam Chair, the creation of an anti-corruption body in and of itself is not. Anti-corruption efforts. We don't want to discourage anti-corruption efforts. We don't want to discourage future transparency efforts. What we're discussing is the willful violation of the efforts. What we're discussing is the willful violation of the Constitution. But what we have here on record is the willful act of the President for transparency and accountability. That's what we have objective fact on. So I just want to make sure that we are not dissuading efforts for transparency and accountability within our government by finding substance in this.
Madam Chair.
Thank you. The Honorable Rodriguez.
Madam Chair, I take exception to this particular ground for impeachment. I personally know a former Secretary of Public Works and Highways, Rogelio. Time and even up to now, there are no ghost projects in Cagayan de Oro 2nd District, nor any substandard project. Now, he would not have accepted if this is a shield, and he would not have continued until he, because of health reasons, has to therefore resign. But during it and get documents, and some have already been recommended for filing. If this were a shield, then there would have been no action of the ICI. But there were many already given to the Ombudsman for investigation and preliminary investigation. So therefore, this is something that it does not give justice to those who have already been appointed and had worked on this particular ICI. And so therefore, I personally know the former secretary, and I was very happy that despite the fact that, you know, he has been retired, he's retired, he took the job because he believed that the ICI can make a difference in stopping all of this flood control mess, and then be able to send the proper cases and documents to the Ombudsman, which is the jurisdiction over cases of graft and corruption and plunder. Thank you very much, Madam Chair.
Thank you. Next is the Honorable Lord Ansuan.
Madam Chair, the body of the complaint does not contain any express provision in the ICI's charter to political opponents, nor does it contain any instances of limiting of any instances or policy or rule exempting allies. In fact, I remember that even the President's son was summoned to the ICI. Nor does the complaint state any rule by the ICI which bars or obstructs any investigation.
The Honorable Garbin.
Thank you, Madam Chair. The establishment of such body like the ICI falls within the President's executive and administrative discretion, which we have constantly regarded as political question and which is outside the ambit of this honorable body.
Own manifestation on this.
Is this on the fifth offense?
Ano po yun?
Is that on the fifth offense?
Yes, yes.
You may proceed, Honorable Abante.
Although the ICI should have been given more powers to investigate and to subpoena, na hindi po nangyari. Ito pong si Attorney Andre De Jesus, ng Taong Bayan. I just would like to say na walang kwenta po itong sinasabing itong tinatawag natin na respondent created the ICI to shield corrupt allies. Siguro po, kung siya ang presidente, gagawin niya yun. But I think it's this, no? Palagay ko, ibasura na ho natin ito sa lalong madaling panahon. Maraming salamat po, Madam Chair.
Madam Chair. Madam Chair.
Honorable Abante, let us be cordial to our complainants.
Madam Chair.
Nonetheless, we recognize the Honorable Erice.
Madam Chair, nakakaasar na rin po kasi.
All your...
As evidenced by the resignations of the two members of the ICI. Pero hindi po nangangahulugan ito na ang Pangulo ay ginawa ito para pagtakpan yung kanyang mga allies. Ito po ay isang speculation at isang conclusion. rather than a fact. So, Madam Chair, I don't think that this is a sufficient basis to impeach a president. Thank you.
Thank you, Honorable Orice. The Honorable Vice Chair Dumogan.
Thank you, Madam Chair. I think we had lengthily discussed. Okay.
For having this exhaustive and lengthy discussion. We've heard, but even the video, we've heard also about the need for personal knowledge with respect to the allegations of the facts in the impeachment complaint, as well as the nexus, which was repeatedly mentioned by the Honorable Delegate. The impeachment complaint of De Jesus is sufficient in substance. In that regard,